Hello, I'm Lisa Speaker with the Speaker Law Firm. We do family law appeals all over the state of Michigan. Today, we're going to talk about whether your client has an appeal by right or an application for leave to the Court of Appeals. It's actually a pretty complex question, so we're going to break it down today into three different areas. First, before the judgment is entered, then once the judgment is entered, and finally, post-judgment litigation. In family law cases, the judgment typically refers to the judgment of divorce or a custody judgment in a paternity case. But before the judgment is entered, your client can appeal orders only by application. They're pre-judgment orders, also known as interlocutory orders, and only an application for leave to appeal is available to the Court of Appeals. Then, once your client obtains a judgment, whether it's a judgment of divorce or a custody judgment, they can appeal by right that judgment, including any of the orders that led up to the judgment. So even though you could not appeal the interlocutory orders at the time they were entered, you can still complain about them on appeal once the judgment is entered. Family law cases have a lot of post-judgment litigation. And in fact, that's where most of our appeals come from once a post-judgment order is issued. So a lot of clients only have applications for leave to appeal from a post-judgment order because any judgment modifying child support, spousal support, or enforcing a prior order, those are all by application only. On the other hand, there are some other types of orders that are appealable by right. For example, a post-judgment award or denial of attorney's fees can be appealed by right, regardless of how much money is at stake. It could be $100 and you can still appeal by right. And then the other one that's appealable by right are custody orders. Now, whether your order actually is a custody order or merely a parenting time order is really a question for another day. It's quite complex of an analysis. And we'll have a video on that for you to help you understand the difference between what order in a custody context is appealable by right or by leave. But just the bare bones of it is that if it's an order granting or denying a change of physical custody, legal custody, or domicile, it's appealable by right. But parenting time orders are only appealable by application. As you heard from the basic guideline I just provided, this is not a one-size-fits-all proposition, and your client's appeal should be analyzed on a case-by-case basis. Don't hesitate to contact us if you need help analyzing your client's case and whether they have an application or an appeal by right. In addition, if you want more information about analyzing whether a custody order is appealable by right or application, use the link below and you'll have access to the next video about that very topic.